streamed over the internet, which means that any member of the public can log on and watch this proceeding just as if we were in person. All defendants, I want to advise you, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding. Today, we will hear matters such as bondies. This calendar is for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. I encourage defense counsel today to consider permitting arraignment at this time. All right, who do we have first?
Good afternoon, Judge. We have position 4, Mr. Brunson, in front of you.
Okay, good afternoon, Mr. Brunson. Your case is 22 CR 001533Y, in which you're charged with possession of marijuana less than an ounce with an offense date of March the 16th. I've advised you of your rights. Do you object to this video hearing?
No, ma'am.
Do you object to your attorney assisting you with this by video?
No,
Your Honor,
Yes.
I do apologize for interrupting. Mr. Brunson has elected to proceed pro se on a plea offer from the state.
All
That's
right.
correct, Your Honor.
Okay, so Mr. Brunson, you are declining the services of the public defender's office at this time, and you want to take a plea.
yes, ma'am.
I'm sorry?
Yes, ma'am.
And you're sure that that's what you want to do after speaking with the public defender?
I mean, like, I was trying to get her to.
Wait a second. Don't tell me too much, because the state is listening, and they may, make some different recommendations. But I do want to know if you want to go forward with taking a plea at this time.
Yes, ma'am.
And you sure you don't want to speak with Ms. Gant again and hear her recommendations? It sounds like you may have had some additional questions.
Because like I got so much going on. My mom battling breast cancer. I got 2 children and a third one on the way. I'm just trying to go home. I'm just trying to figure
This is a bond hearing, Mr. Brunson. So, a bond perhaps could be set today. I just want to make sure that you understand. Why don't, Ms. Gant, would you be willing to speak with him again?
Yes, Your Honor.
I think, Mr. Brunson, if Ms. Gant, would you give the jail a call? I think you should speak with him one more time. And if he is absolutely sure, we'll go forward and take that plea today. Okay?
Absolutely. And may I have the number in the chat, please, for the jail?
Is there a number that the jail could put into a chat?
Yes, I can put it in.
Okay. If Mr. Brunson could go ahead and give Ms. Gant a call, and we take a position that's not assigned to Ms. Gant, I'm happy to take the plea, but I just want to make sure that he understands all of his options at this vantage point.
Okay, you can, I'm gonna put it in the chat now.
Thank you.
Can we take someone else in the meeting? Ms. Gant, what positions are you assigned to today?
Your Honor, unfortunately, I don't have the position,
got it.
but I have the clients. I have the first half of the calendar, Your Honor.
Okay, so if we can take any position that's not assigned to Ms. Gant, that'd be great.
Over there for me? She's gonna call you over there. Come on, Mr. Walker. Next, we have position 16, Walker. Withal.
Okay, pronounce your last name for me, sir.
Walthall.
Walthall. Mr. Walthall, I'm Judge Melanie Williams. Your case is 22 CR 001531E, in which you're charged with 1 count of battery family violence with an offense date of May the 10th of 2021. I've advised you of your constitutional rights. Do you object to the video hearing?
No.
Do you object to your attorney assisting you by video?
No.
Who represents Mr. Walthall?
I do, Your Honor.
Oh,
This is
thank
Miss
you.
Kim.
Good
Yes.
to see you, Ms. Kim. All right, before I begin, he's recommended not first offense, Mr. Howard. So can I have the history, please?
This is 9th arrest. He had history out of North Carolina, 2013. Misdemeanor larceny conviction. I think it was amended from the common law robbery arrest. 2019 out of Florida for business conduct without a license. Last arrest in Georgia was 2019. Obtaining dangerous drugs by fraud. It just says transfer out of Hateville. 2013 marijuana possession dismissed. 2011 shoplifting arrest. 2011 trespass arrest. 2010 marijuana, NOD, and 2008 trespass dead dock.
Okay, confirming, I didn't hear anything violent.
No,
Confirming, okay.
yeah, I think the
you.
robbery, the common law robbery was reduced to larceny. So
Okay.
outside of that, no.
So potentially, okay, thank you. Whose case is this for the state?
Good afternoon, Your Honor. That's my case.
Good to see you, Ms. Arnold. What is the state's recommendation?
The state is recommending a $4,000 surety bond, no further contact with Nashantis Ridley. Nashantis spelled Nashontis, Ridley spelled Ridley. A stay away from 157 Maury Avenue, Maury spelled Moury, Southwest in Atlanta. A one-day anger awareness and no drugs, alcohol, or weapons. Your Honor, this incident happened on May 10th of last year at the Maury Avenue location. Ms. Ridley advised that her child's father, the defendant here in this case, popped up at her apartment and they got into a physical altercation. During that altercation, Your Honor, the defendant punched Ms. Ridley in the face, causing her to sustain swelling and a black eye. Your Honor, we are concerned that the defendant is a flight risk as he is a multi-state offender. I had that he had 7 cycles from Georgia, 1 from Florida, 1 from North Carolina. And with his last known arrests being in 2019 in both Florida and in Georgia, Your Honor. So we are concerned that the defendant will not return to court. So we are requesting the bond as stated. We did try to reach out to the victim in this case, Ms. Ridley. However, the number was disconnected at the time, Your Honor. Thank you.
All right, thank you. And I'm gonna sound for her just in the event that she is here today. Is the victim last name Ridley present on the screen and wishes to be heard? Ms. Ridley, if you are present, this is your opportunity to speak. All right, hearing none. Ms. Kim?
Yes, Your Honor. Mr. Worthall is 31 years old and he has been here in Georgia for 31 years. He was born here, raised here. He's not a flight risk. He has a 7-year-old child here and he has parents, he has siblings. They are all here. Besides, he also has a physical challenge. Right now, he's disabled because of the accident that happened when he was visiting the event. His ankle and his back are broken, so he's not really well. He cannot walk well. And also, he has been unemployed for the last 4 years because of that disability. So there's no way that he would have any funds to pay for the surety bond. And also, he's qualified and recommended for a signature bond because there was no, even the larceny is 2013, almost 10 years ago, Your Honor. That's very remote. And also, there is, he denies allegation completely. This happened on May 10, 2021, about a long time ago. And he does not believe there was any kind of violence like that. And the victim is not here to testify anyway, because probably it's not, she was not, that it was not true. That's what my client claims. We would like to request for a signature bond. We do not oppose to stay away and no further contact at all. Thank you, Your Honor.
All right, thank you. At this time, the defendant is going to receive a $4,000 signature bond through pretrial services. He is to take the one-day anger awareness course. He must stay away from the address on Maury Avenue. He is to have no further contact with the victim, last name Ridley. He is to have no weapons, drugs, or alcohol as a condition of that bond. Anything further from either party?
No, Your Honor.
All right, best of luck to you, sir. Is it possible for us to take Ms. Watson Cafe's position next?
Who, Judge?
Ms. Watson Cafe, who do you represent?
Tykera Smith.
Is it possible for us to take that position, or is that at the South Annex?
Yeah, that's at South Annex.
Okay, Ms. Watson Cafe, I tried. Hold on for us shortly. All right, okay. Who do we have next at courtroom 2?
Position 4, Mr. Brunson. He's ready with Ms. Gant.
All right, Mr. Brunson. You spoken with Ms. Gant. Do you still wish to take a plea today?
Yes, ma'am.
All right. Whose case is this for the state? Is Ms. Tortorella?
Yes, Your Honor.
It's good to see you. Long time. Will you please put the state's recommendation onto the record?
Yes, Your Honor. The state's recommending time served for the defendant. Your Honor, and just to go through the facts, on March 16th, 2022, around 3:26 p.m., Officer R. Sparks was working in plain clothes at the Lakewood MARTA station located at 2020 Lee Street Southwest in Atlanta, Georgia, with Officer B. Cook. The defendant, Quantavious Brunson, approached the undercover officers with the intent to sell the officers marijuana. The defendant advised the officers that he had that sherbet and presented a black bag containing a plastic bag with 20 ounces of marijuana inside. The defendant was asked if he had a scale, and the defendant responded, "No, that's how you get effed up." Badges were displayed to the defendant, notifying him of MARTA police. The defendant was taken into custody without incident, and these events did occur in Fulton County, Georgia. Your Honor, there are no relevant convictions. And just to let the court know, he does have a 2 felony open cases. One is 20 CP 188907, and the other one is 20 CP 200684 for terroristic threats. It's a felony offense. And an open misdemeanor case before Judge Edie for simple assault, and that's 21 CR 004601Y. The reason for the state's recommendation, Your Honor, is this is a possession of marijuana offense, and we do not feel like we would take this all the way to trial, Your Honor. So we try to resolve it today.
All right, Mr. Brunson, since you are proceeding pro se, I'm going to have to ask you some questions to make sure you understand. Now, in order for me to take this plea, you cannot contest it in any way. You have to agree with the state's facts that she just said. You have to say that this happened in Fulton County and that they had the right person, which is you. Do you agree with all of those points at this vantage point?
Yes, ma'am. Can I add something though?
No. If you're going to take a plea to what they're saying, you cannot dispute any of those facts. So the question is, it seems as if you may have some, and this may affect your employment record. There are a lot of ramifications from a plea. I believe Ms. Gann explained some of them to you, but the best thing for you to do really is to contact an attorney regarding this if you have any questions or if you're disputing the facts as presented by the state. Do you dispute those facts?
Man, I take the plea.
No. Now, the question is not, I'll take a plea, is do you agree with what Ms. Tortorello just said? If not, the best thing, it seems to me that your concern is getting out today. You will be given a bond today, regardless of this decision. But let's not go there. Let's make sure. Do you agree with what Ms. Tortorello just said without adding any additional facts?
Yes, ma'am.
You do, in its entirety.
Yes, ma'am.
And you understand that taking a plea may affect your criminal record, your employment records in ways that only an attorney could explain to you?
Yes, ma'am.
And you still want to take the plea?
Yes, ma'am.
Okay, and are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied, and you understand that you had a right to an attorney today, but you declined to use the services of a public defender or any other attorney in taking this plea?
Yes, ma'am.
And in representing yourself, you understand the implications of this plea, meaning that you understand that this plea may affect you in ways undisclosed to you at this time by the court.
Yes, ma'am.
And no one has forced or coerced you to taking this plea today.
Yes, ma'am.
And no one has promised you anything.
Yes, ma'am.
And you understand that you would have had a right to go to court and have the state prove these charges against you, and you still want to take this plea?
Yes, ma'am.
And you're prepared to give up your right to go to court, and you agree with what Ms. Tortorello just read onto the record?
Yes, ma'am.
And you don't dispute that it was you?
No, ma'am.
And you don't dispute that this took place in Fulton County?
No, ma'am.
And you don't dispute the facts again, as Ms. Tortorello presented them?
No, ma'am.
And you understand the requirements that basically the time that you serve will result in a guilty, that will be on your permanent criminal record. As to the charge of possession of marijuana less than an ounce, how do you plead?
Guilty.
I accept your guilty plea. Ms. Tortorella, how are we going to get paperwork to Mr. Brunson so that we can work on him getting out?
Yes, Your Honor, if you would like it right now, I would have to work on it right now if you give me a moment.
That would be ideal. How will we get it to the jail?
I think I already got an email stating who I need to send it to.
Okay, if you would work
No,
on
you
it.
have to, I'm sorry, Judge, for interrupting. I just sent an email to her to let her know she need to send it to Miss Holly Bridgewater once she fill out her part, but it has to go to the jail for Mr. Brinson to fill out his part on it. So it has to go to the jail first, then back to the solicitor, then to Miss Holly, to Miss Bridgewater.
Right, that's what we were saying. It needs to go to my concern is getting it to the jail for Mr. Brunson's signature. So how do we do that? Ms. Lewis?
The solicitors will have to send the paperwork through an email or fax to the jail for him to sign.
Okay, and then we'll send it back to Ms. Bridgewater. I'm assuming. All right.
I need to know in the jail who's gonna receive it. Well, Miss Torres.
You can send it to Sergeant Johnson. She's the supervisor with courts.
Do you have her email? Can you put in the chat for me, her first name and last name, so I know? Please.
All right, while we're working on that, is there another position we can go to?
Judge, he's getting time served. How many
Yes.
days has he been in?
It says on the, Ms. Tortorella, we confirm the number of days it says 2 days, but let's confirm. Okay. Is he getting credit for the 2 days that he served?
Yes, Your Honor. The incident occurred on March 16th and it's March 17th today.
Okay, so this paper was wrong. So it's 1 day?
Correct. Oh, yes.
I think
Credit
he gets
first time
2
served.
for one.
Oh, they get 2 for
Oh,
one.
that's why.
Oh, you good?
So we'll say,
2
serve
days.
2 days, credit for the 2 days served. All right. All right, can we move to another position while we help Mr. Brunson work on his paperwork?
I'm good to go, Judge.
You're good to go with me. You'll still have to sign some paperwork though. Best of luck to you.
Thank you. Thank you, Judge.
And right is correct. If you have other holds, you may still be in the jail, but you're done with me in this
All
case.
right. Yeah. I need your help.
Please don't forget to send over the email that I need to.
Oh, I sent it already. That's why I'm in this.
All right, who do we have next?
What, why does it keep popping up? Why is it doing that? Next, we have position 3, Mr. Booker.
Okay, good afternoon, Mr. Booker. Your case is 22 CR 001532G. In which you're charged with 1 count of battery family violence with an offense date of December the 13th of 2022. I've advised you of your rights. Do you understand your constitutional rights? Do you object to a video hearing? All right, thank you. First arrest, so we'll go straight to state. Whose case is this for the state? Is it Mr. Tortorella?
Yes, Your Honor.
I apologize that I'm asking you to multitask, but if you would please give me the state's recommendation here.
Yes, Your Honor. For the battery family violence offense, it's a $6,000 surety bond. That's and the conditions are that the defendant do not return to the incident location located at 1760 Northside Drive, Northwest, apartment 330 in Atlanta, Georgia. That he have no contact with the victim. And her name is Markeisha Campbell, and Markeisha is spelled Markies, as in Sam, HA, and Campbell, traditional spelling. That he take a 1-day anger management course, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on December 13th, 2021, Officer J. Figuero of the Atlanta Police Department responded to a call at 1760 Northside Drive Northwest, apartment 330 in Atlanta, Georgia, regarding a dispute in progress. Upon arrival, the officer met with the victim, Markeisha Campbell, who said that she and her fiance, defendant Rodney Booker, were having a conversation in the living room, which turned into an altercation. The victim said she was talking to the defendant while she was sitting down in the living room floor, and the defendant got upset at the victim, and the victim told the defendant to shut up. The defendant proceeded to hit the victim with a closed fist on her forehead, which left visible bruises and lacerations on the victim's face. The victim further advised that the defendant grabbed her by the leg and dragged her all the way to the kitchen. The victim said she grabbed the defendant by his hair in attempts to escape from him. The victim also said the defendant bounced her head on the kitchen floor. The victim said the defendant asked her to let go of his hair. And after she did let go of his hair, the defendant started kicking the victim while she was laying down on the kitchen floor. The defendant then grabbed a glass cup and turned around and threw the victim on the kitchen table and started hitting her, and then left the apartment. The photos were taken of the victim's injuries. The officer showed the victim a photograph of the defendant, and the victim identified the defendant as Rodney Booker. And all these events did occur in Fulton County, Georgia. Your Honor, this is his first offense. However, due to the violent nature of what occurred here, the state is not recommending a signature bond. It is definitely foreseeable that the defendant will intimidate this witness, the victim. He knows who she is. They were in a relationship. He knows where she lives. He knows who she associates with. And the nature of his actions against the victim are concerning and true acts of an egregious violence against the victim, Your Honor. And therefore, we are not asking for a signature. We are asking for that you impose a surety bond of $6,000. Nothing further from the state.
Thank you. This is your case, Ms. Gant.
Yes, Your Honor, thank you. Mr. Rodney Booker is 28 years old. He has been in the Atlanta area since 1996. He has community ties here, including his family and a 2-year-old daughter. He is the primary caretaker of that child, and he is not receiving any child support. Your Honor, we are opposed to the stay away at 1760 Northside Drive. Mr. Booker informs me that that is his residence and that Ms. Markeisha Campbell does not live there. Your Honor, Mr. Booker is a high school graduate. He also has some college credits toward a business management and accounting degrees. He is currently employed at Delta Airlines as a ramp agent. Mr. Booker denies the allegations, and Your Honor, this is my client's first arrest. He is presumed innocent. He is recommended for a signature bond. Therefore, I'm requesting that signature bond on his behalf. This incident occurred this incident is alleged to have occurred on December 13th, 2021. I have spoken to Ms. Markeisha Campbell, and she confirms that she and Mr. Booker are in fact in contact with each other without incident. She wants to continue having contact with him. Therefore, again, I am opposed to the stay away and would ask that Your Honor order a no violent contact order. Thank you.
Your Honor.
Is Ms. Campbell the mother of this child? Is Ms. Campbell present on the Zoom conference? Let's do that first. I'm something for Ms. Campbell. Okay.
Yes, I am.
Okay.
Oh, Ms. Campbell is present on the Zoom conference. Ms. Campbell, if you would like to make a statement, you are not required to do so. I need you to turn on your camera so that we can identify you. I see that you turned on and off your sound, but there should be another button to turn on your video so that we can see you, Ms. Campbell. While Ms. Campbell is trying to work that out, Ms. Gant, you were going to make some statements. You were indicating that you believe that that was their child together.
No, Your Honor, he informed me that that is not, he does not share that child with Ms. Campbell.
Your Honor, if I can add, she did She did reach out to the state. She does still live together with him, which is concerning. She is pregnant with his child. And even though she does not want to press charges, Your Honor, the state is concerned. And that's the reason why we are asking for a stay away and for no contact. As you are aware, Your Honor, the cycles of domestic abuse, there is a period where everything's okay, and then everything returns again to the abuser against the victim. The abuser may start abusing the victim again after that cooling off period. So if Your Honor can please take that into consideration, even if he is given a signature bond, Your Honor, we do ask a stay away and no contact.
I really would like to hear from Ms. Campbell. Ms. Campbell, were you able to activate your Zoom so that we can see you?
No, ma'am, it's not letting me because I had already joined the Zoom.
If you would please go out and come back in, I'd like to ask you some questions.
Okay.
And Your Honor, if I may, while we are waiting for Ms. Campbell to rejoin, I would just ask.
Are you going to speak, Ms. Gant, to the cycles of domestic abuse?
Yes, Your Honor, that my client has never been convicted, and he is in fact presumed innocent. There are no history of any convictions for Mr. Booker that concern Ms. Campbell or anyone for that matter.
All right, thank you. I'm familiar with both the defense and state position as the cycles of domestic abuse, and I would like us all to work on a joint law review article on that at some point. Now, I'm not sure we're going to be able to hear from Ms. Campbell. She seems as if she was really trying to speak here. What I'm going to do is Mr. Booker is going to receive a $2,500 surety bond. Ms. Gant, now the question I had is, you said that he had indicated to you that he does not live there. She does not live there with him. That is his address. But the state is indicating that she does live there. So that is the point that I was trying to get her to clarify as to whether or not she still resides at that location. So what information do you have regarding that, Ms. Gant?
He informed me that he lives at 1760 Northside Drive, 330. She informed me that she lives at 1250 Powder Springs Street in Marietta, Georgia, and that he sometimes visits her there or sometimes lives there.
And Your Honor, that's contrary to what she advised our victim advocate.
All right, here's what we'll do. At this time, he is to have no further contact with the victim, last name Campbell. He is to stay away from that address if the victim is living at that location. If he provides, if information is provided to the court and the state that she no longer resides there, he can return to the address at 1760 Northside Drive. He is to have no weapons, drugs, or alcohol as a condition of this surety bond, and he will be reset to the SAP calendar on March 31st, where visitation, not visitation, but where contact and the stay away can be revisited.
Your Honor, if I may add something, if you'll be inclined, maybe he can have a one-time escort with a deputy to just assure that she's not living there, and then maybe he can return to his residence.
I have no objection to the one-time escort. I will add that as well. All right, I believe we've addressed all conditions as it pertains to Mr. Booker's case. Is there anything further from either party?
Is the bond 2,500? Is that correct?
Yes, 2,500.
Thank you, Your Honor.
All right, best of luck to you, Mr. Booker. Who do we have next?
Position 2, Mr. Belt.
All right, good afternoon, Mr. Belk. Your case is 22 CR 00153 in which you're charged with theft by taking with an offense date of January the 22nd of 2022. I've advised you of your rights. You object to the video hearing?
No, ma'am.
All right, do you object to your attorney assisting you by video?
No, ma'am. I do not.
All right. All right, first arrest, we'll go straight to Ms. Tortorello.
Your Honor, the state's recommending for the theft by taking a $5,000 surety bond for that to remain as set. However, we are okay with a signature bond. The conditions is that he do not return to the incident location at, it's the Pond City Market, 675 Ponce de Leon Avenue in Atlanta, Georgia. That he have no contact with the victim in this case, Brittany Days, and the last, Brittany traditional spelling, the last name spelled D as in dog, A-I-S. That he take a theft class, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on January 22nd, 2022, a Detective R. Jefferson of the Atlanta Police Department responded to the Pond City Market, the incident location at 675 Ponce de Leon Avenue in Atlanta, Georgia. The victim, Brittany Days, advised the officer that on said date, the defendant, Joel Belt, had asked her to use her cell phone to get on social media because his phone battery was dead. I'm sorry, Your Honor, are we in position to Mr. Belk?
Yes.
Okay, good. I'm sorry. The victim said she unlocked her cell phone and handed it to the defendant so that he could check his social media. The victim said that after 20 to 30 minutes, the defendant handed her back her cell phone and left the location. The victim advised that after the cell phone was returned to her, she saw a message from her Cash App account, which stated she had sent $500 to the Cash App name at Seven Ways, and that's spelled X-E-V as in Victor, E-N, capital W-A-Y-S. The victim said she asked around the location and was provided the defendant's photo, first and last name and phone number. Detective Jefferson verified the defendant's identity and information provided to him on the Accurate LexisNexis system, and these events did occur in Fulton County, Georgia. Your Honor, he only has one cycle, which is this case, and due to this, that this is the reason why we are not opposed to a signature bond. Nothing further.
Right. Thank you, Ms. Gant.
Thank you, Your Honor. Mr. Joel Belk is 19 years old. He has been in the Atlanta area since childhood. He does have family in the Atlanta area. He has earned a GED. He is self-employed. He states that he is the CEO of Seven Ways, which is a limited liability company. He sells clothing and also makes music for Apple and Spotify. Your Honor, we are unopposed to the stay away and the no contact orders. We also are opposed to the theft class. My client has no prior convictions, and given that this is his first arrest, Your Honor, I'm requesting a signature bond. Thank you.
All right, at this time, Mr. Belk is going to receive an $8,000 signature bond through the jail. He is to stay away from Ponce City Market. He is to have no weapons, drugs, or alcohol, the condition of this bond. I don't believe there are any other conditions I'm going to impose. I will not impose that theft class at this time. And I will say that he has had no further contact with the victim, last name Days. Is there anything further from either the state or defense?
Nothing further, Your Honor.
All right. Best of luck to you, Mr. Belk, and make sure that you do not return to the Ponce City Market. If you do, that's a violation of this bond, and the jail will welcome you back.
Yes, ma'am.
All right, best of luck to you. Who do we have next?
Position 5, Mr. Clark.
All right, good afternoon, Mr. Clark. Your case is 22 CR 001534A, and what you're charged with simple battery family violence with an offense date of March the 16th. I've advised you of your constitutional rights. Do you understand constitutional rights?
Yes, Your Honor.
Do you object to the video hearing?
No, ma'am.
All right, and do you object to your attorney helping you by video?
No, ma'am.
All right, I appreciate that. Mr. Howard.
Counted 33 total. Last arrest was 2019, fleeing an officer. 2010 probation violation, possession of cocaine. 05 conviction for 2 counts of disorderly conduct. 02 robbery conviction, ag assault, 2 counts conviction, and possession of a firearm by convicted felon. I think that's it. As far as violence.
And not recommended. All right, Ms. Tortorella.
Yes, Your Honor. We're recommending for the simple battery family violence a $3,500 surety bond. The conditions is that he do not return to the incident location at 340 Boulevard Northeast in Atlanta, Georgia. That he have no contact with the victim, Cecile Burns, who I believe is on the Zoom call today. A 1 anger management class, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on March 16th, 2022, around 8:11 p.m., the defendant, Alexander Clark, did commit simple battery family violence against the victim, Cecile Burns, by slapping her on the left side of her face with an open hand after a verbal altercation became physical. The victim is the mother of the defendant's child, and the incident occurred at 340 Boulevard Northeast, Atlanta, Fulton County, Georgia. Your Honor, the reason for the bond recommendation, this defendant has 32 cycles. His last arrest was a fleeing or attempt to elude, and it looks like it's a felony offense, Your Honor, because it was coupled with some traffic violations, including reckless driving. It's in our system, Your Honor, but it hasn't been accused by our office. It occurred in 2019. His history goes all the way back to 1992. He's been convicted of aggravated assault and robbery out of Fulton County Superior Court back in 2003. And in 2010, he had another felony, possession, purchase of unlawful controlled substance at a Cobb County Superior Court. Your Honor, he poses a risk of reoffending due to his record, and also to commit felony offenses while out on bond, Your Honor. So therefore, we do feel a $3,500 surety bond for this matter is more than reasonable.
All right, and please tell me again the name of Cecile. What was the last name, Ms. Tortorella?
Cecile, I believe, let me look up the Burns.
Burns, okay. All right, Ms. Gant, would you prefer to go first, or would you prefer to allow Ms. Burns to make a statement if she'd like to do so?
Your Honor, I would like to go first. Thank you.
All right, go ahead, Ms. Gant.
All right, thank you. Your Honor, Mr. Alexander Clark is 50 years old. He has been in the Atlanta area since 1981. He shares a son with Ms. Burns, a 3-year-old, and a 1-year-old daughter. He also has a 1-year-old daughter. Your Honor, he informs me that the 340 Boulevard Northeast Atlanta is the location of a hospital at which his son was receiving medical care. At this time, I have been unable to establish whether or not the child needs to continue returning to that location for medical care, and I would ask that Ms. Burns advise the court regarding that. Nevertheless, the parties do not live together. I have been in contact with Ms. Burns. She states that she wants contact to the extent that they can exchange the children. Mr. Clark, that is his wish as well. So I would ask that the court order a third party transfer for exchange of the children. And again, we are unopposed to a no contact order. That will certainly take care of the state's concerns regarding any risk of reoffending. And clearly my client denies these allegations. He states that in fact, Ms. Burns is the person who slapped him while he was holding the child. He states that he was merely asking her about injuries or the condition of the child. He states that his son's throat was swollen and that he noticed a bruise or a swelling on the child. He was merely asking Ms. Burns about what happened to the child, and she became angry and struck him. Further about Mr. Clark's background, he is employed at DoorDash, and he is in the process of renewing a business license so that he can become self-employed again. Now, I acknowledge my client's history. However, what I heard is that his last conviction for violence was 2002, 2003. That is almost 2 decades, Your Honor, and I believe that it is too remote for this court to consider. Your Honor, I am requesting a signature bond on Mr. Clark's behalf. That 2019 case is open. He is presumed innocent in that case, in this case as well. I'm requesting a signature bond. If Your Honor is not inclined to grant one, then a bond of no more than $1,000. Thank you, Your Honor.
Thank you. Ms. Burns, if you would like to be heard at this time, this is your opportunity to do so. You do not have to make a statement to the court, but if you would like to do so, please turn on your camera and unmute your screen. And all right, would you like to make a statement to the court today?
Yes.
Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes.
All right, you can put your hand down. What would you like to tell the court at this time?
I would like to say that I have a police report proving that the allegation that Alexander made is false. He abused me. He attacked me in front of my son. I'm not sure why he's not getting accrued to a child charge as well, but that's something
Honor,
else.
I object to this testimony. I would ask that the court limit the complaining witness's testimony to her wishes for contact.
Your Honor, the victim has the right to.
I understand both positions of the state. I'm going to permit her to continue. Ms. Burns, please limit your testimony in some manner. Please do not speak directly to the allegations, but I will allow you to continue. All right? And I understand that you don't agree with what was said by the parties. But I do have questions about whether or not you wish to contact, whether you wish to have contact with them.
No, not at all.
All right. Do you fear him?
Yeah, absolutely. He is very dangerous. This is not our first rodeo. I just fled a domestic violence shelter because he figured out where me and my children was. We went to a hotel for a whole month because of that. I just got my new apartment on March 1st. I can't help that my son caught strep throat. Okay, he was in the hospital drilling me as from a bad parent. I simply said, if you want to know anything about the baby, ask the doctor. He said, B, who are you effing talking to?
Objection,
and slapped me. I even have a witness from the hospital, a patient who's across the hall that verified the information. And that's it.
Thank you. I appreciate that, Ms. Burns. At this time, Mr. Clark is going to receive a $3,500 surety bond. He is to have no further contact with the victim, last name Burns. He can arrange transport of his children through a third party, but he is to make no direct contact with her, either through social media, email, phone, or by any other method. He is to have no weapons, drugs, or alcohol. It does not appear that the child has an ongoing condition. Ms. Burns, is there any ongoing condition such as you would be required to take the child back to the hospital on a regular basis? Ms. Burns, I apologize. I know you've logged off. It sounds as if you all went to the Wellstar location on Boulevard one time. Does your child go there regularly?
He was actually born there November 2018. His primary care physician is Dr. Thomas at another location, but I took him to the emergency room for a strep throat.
Okay.
Unfortunately, the strep throat has caused bacteria in his throat. So we're currently at Children's Healthcare of Atlanta at Scottish Rite. He has been admitted here. I've been told he's going to be here for about 3 or 4 days. He was born with bilirubin. Unfortunately, that has reoccurred in him. So now we have to get that bilirubin out of his system. So we're going to be here for a couple of days.
Okay. So I think I understand. Thank you so much, Ms. Burns. I'm not going to impose to stay away from the hospital. It does not seem like that's an incident location where they will be offered, but he still must not have contact with the victim and can arrange transport through a third party. Is there anything? Oh, and he used to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either the state or defense as it pertains to Mr. Clark's case?
No, Your Honor.
Nothing further, Your Honor.
All right, thank you. Mr. Clark, I see you have a question. The best thing for you to do is to speak to Ms. Gant so that you can clarify any issues you may have, because I don't want you to make a mistake and say something on the record that the state will end up using against you. Do you have a question about your bond?
No, ma'am. It was the
Remain silent, Mr. We don't want to jeopardize your case at all.
yes, ma'am. How do I speak to Ms. Grant, Your Honor?
I will give you a call at the jail.
All right, best of luck to you, sir.
May you keep them there, Your Honor. I'm asking courtroom 2 to keep them there so that I can give them a call before the hearing concludes.
That's fine.
Thank you.
All right.
Was that a good bond?
Good bond, yes. Ma'am.
Okay, thank you.
What do we have next?
Position 7, Mr. Donaldson.
All right, good afternoon, Mr. Donaldson. Your case is 22 CR 001538C, in which you're charged with simple battery family violence with an offense date of March the 25th of 2020. I've advised you of your constitutional rights. Do you object to the video?
No, Your Honor.
You object to your attorney assisting you by video?
No, Your Honor.
All right, thank you. Mr. Howard?
It's his third arrest. Last was 1999, suspended license.
And he is recommended, okay, sorry. All right, Ms. Tortorello?
Yes, Your Honor. The state's recommending for the simple battery family violence charge a $2,000 surety bond. The conditions is that he do not return to the incident location at 1504 Real Lake Drive. Real is spelled R as in Robert, EEL as in log, Southwest, South Fulton, Georgia, 30349. That he have no contact with the victim, and his name is Theodore Hale, who is present at the Zoom hearing today. That he take a 1-day anger management course, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on April 24th, 2020, an officer, Jay Campbell of the South Fulton Police Department, responded to 1504 Real Lake Drive, South Fulton, Georgia, in reference to a physical assault. Upon arrival, the officer spoke with the victim, Theodore Hale, who advised he was assaulted by his roommate, defendant Anthony Donaldson. The victim advised he questioned the defendant about why he was walking around the residence with an attitude. The defendant said he had a lot going on and he didn't want to talk about it. The victim said the defendant went upstairs to a vacant bedroom where some of his property was being stored. The victim said that at this time, he asked the defendant when he was going to pay the $800 he owes for rent. The defendant responded to the victim that he had personal things to handle. And then the victim said the defendant then charged at him and pushed him with both hands, causing the victim to be pushed out of the room. And the officer did not observe any injuries on the victim. A warrant was taken out against the defendant that day, and all these events did occur in Fulton County, Georgia. Your Honor, we are opposed to a signature bond. Given the fact that this happened almost 2 years ago, he just got arrested for this. The police took out a warrant around that time, and just what has occurred at the with these facts of this case, the way he pushed him, Your Honor, it's been a while, Your Honor, and honestly, we do object to a signature bond. Nothing further from the state.
All right, Ms. Gant?
Thank you, Your Honor. Mr. Anthony Donaldson is 51 years old. He has been in the Atlanta area for 20 years. He has family here, including his cousin, which is, of course, Mr. Hell. He also is the proud father of 4 children. He has 2 minor children ages 15 and 1 grandson. He is paying child support for the 2 minor children. Your Honor, we are opposed to the stay away at 1504. Yes, we're opposed to that stay away at 1504 Real Lake. That is Mr. Hell's residence. However, I spoke with Mr. Hell. He wants to have Mr. Donaldson return to that home. He also wants to continue having contact. So I would ask the court to not issue a stay away and instead order a no violent contact order. Mr. Donaldson completed high school. He also has a bachelor's in finance. He is self-employed. He has his own finance company. Your Honor, I acknowledge that my client has 3 cycles. However, his last arrest was in 1999 for a driving offense. So essentially, he has no convictions for violence whatsoever. Therefore, I am requesting a signature bond as he is recommended. Again, we are opposed to the stay away and the no contact orders. Thank you.
All right, thank you, Mr. Hale. I see that you are present on the Zoom conference. If you would like to make.
Your Honor, I do apologize. Regarding the allegations, Mr. Donaldson denies the allegations. He denies making any physical contact with Mr. Hale. He also states that he called the sheriff's department to follow up regarding this incident. And he states that he was informed at that time that there was no warrant on him, and because he understood that Mr. Hale did not want to press any charges. And I do apologize for not bringing this to the court's attention.
Your Honor, the police report states that the officer filled out a warrant, and we actually have a warrant that was taken out that day.
Thank you, Mr. Hale. This is your opportunity to be heard. Would you like to make a statement?
Yes.
All right, Mr. Hale, please raise your right hand. Do you swear and affirm that, I see you're in a car. Are you driving or are you completely pulled over?
I'm pulled over because where I work, I can't do video. I have to get off the premises.
Okay, I understand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, what would you like to tell the court?
Yeah, it was an ego thing, and it wasn't that serious. And the next day I called to, what do I do to just, because the officer said he just wanted to talk to Anthony. Was it. And we tried for a year to find out what's going on, because I would ask Anthony probably a couple of months ago, have you found out anything about, in case you get stopped, if somebody stopped you, if there a warrant or anything? And he said he'd been trying to. So we didn't have any information so we can come to the courts and get this resolved.
All right, thank you. At this time, Mr. Donaldson is going to receive a $4,000 signature bond through pretrial services. He is to have no further violent contact with the victim, last name Hale. He is to take the one-day anger awareness course and have no weapons, drugs, or alcohol as a condition of his bond. Is there anything further from either party?
Nothing further, Your Honor.
All right, best of luck to you, Mr. Donaldson. We can move to the next position.
Your Honor, if I may, the complaining witness she's back on the call, Zoom user, and she is reaching out to me in the chat, and I would recommend that she address her questions to the court, Your Honor. Or
Okay.
come on to testify, I believe Miss Campbell is her name, Markeisha.
Is Ms. Campbell able to turn on her Zoom conference? Ms. Campbell, if you have very specific questions, you have to turn on your camera. Did you want to make a statement at this time very quickly? Because we've moved on from that case.
Yes.
All right, Ms. Campbell, you still have to turn on your camera. That is a requirement. It's the same as coming to court. I understand that it may be difficult, but we have to be able to identify you for the purposes of this conference.
It's not me, it's actually my phone.
All right, well, until you can physically be present on the Zoom, I cannot hear from you at this time. Perhaps Ms. Gant might be a good person to answer some of those questions. If not, we will move to the next position and hopefully you will be able to make it work before the end of the Zoom conference. Who do we have next?
Judge, position 7, was it through pretrial? A signature bond through pretrial?
Yes, yes.
Next, we have position 12, Mr. Sanchez.
All right, good afternoon, Mr. Sanchez. Your case is 22 CR 001527F, in which you're charged with criminal trespass with an offense date of March the 16th of 2022. Do you understand your constitutional rights?
Yes.
Do you object to the video hearing today? I'm sorry, do you object to the video hearing?
No.
Keep your mask up.
All right, do you object to your attorney assisting you by video?
No.
Okay, thank you. I have first arrest, so we'll go straight to Ms. Arnold.
Yes, Your Honor. The state requested a breakout for this position.
All right, very briefly, before we go to that breakout, I see that you were able to get it on Ms. Campbell. Ms. Campbell, what would you like to tell the court at this time?
Hello?
Yes, Ms. Campbell.
Oh,
Hello?
Yes, Ms. Campbell, what would you like to tell the court very quickly?
Yes, I would like to request for a signature bond on Mr. Booker's behalf. The incident happened, and yes, the police was called, but when I talked to the investigator, I let him know my situation, and basically that situation was just taken out of hand. I feel like I could have left the apartment because It was not my apartment, but I do live there. We're currently still together and have been since that situation. There hasn't been any other incidents or anyone calling the police or any disturbance between us. I feel like the bond is a little too extensive for that situation. No children, where he does have children and he has one on the way, but there were no children on the premises when the incident happened.
All right, thank you, Ms. Campbell. I appreciate you making this statement to the court. My ruling will stand at this time. All right, can I be placed in that breakout room with, who needs to be in there? Ms. Arnold, Ms. Kim?
And Mr. Hopkins.
Mr. Hopkins? I apologize, I was muted and I left the entire proceeding. The $500 surety bond will remain as set. The defendant is to stay away from the Hilton Hotel. He is to have no weapons, drugs, or alcohol should he make bond, and he is to undergo a behavioral health, a BH evaluation.
Thank you, Your Honor.
Is there anything further from either party?
No, Your Honor.
No, Your Honor.
Nothing further.
All right, best of luck to you, sir. We can move to the next position.
Position 10, Mr. Pierce.
Wait,
She gave you a $500 good bond.
what happens if I don't pay it? What happens if I don't pay it?
I'll explain it to you.
Okay.
All right, are you Tremaine Pierce?
Yes, ma'am.
All right, Mr. Pierce, do you, your case is 22 CR 001525B, in which you're charged with battery, substantial physical harm with an offense date of October the 26th of 2021. I've advised you of your constitutional rights. Do you understand your rights?
Yes, ma'am.
You object to the video hearing?
No, ma'am.
You object to the attorney assisting you by video?
Say it again.
You object to your attorney assisting you by video?
I don't know what that means.
Your attorney's on the screen. They're not there with you. Can she help you by video?
Yes, ma'am.
Okay, thank you. That was our, that's what I was trying to clarify. Ms. Arnold?
Yes, Your Honor. The state is recommending a $3,500 surety bond, a stay away from 1270 West Peachtree Street Northwest in Atlanta, which is the labor staffing of Atlanta. No further contact with Miss Marixa, Marixa, Butler - Thomas, both spelled traditionally, a one-day anger awareness, and no drugs, alcohol, or weapons. Your Honor, this incident happened on October 26th of last year at the labor staffing of Atlanta. Ms. Butler Thomas advised that she works for the agency, and on the day of the incident, the defendant came into the office looking for his paycheck. Ms. Thomas told the defendant that he would be able to pick his paycheck up on Friday, per usual, and he became irate. Minutes later, Ms. Thomas came out to the lobby, but was unaware that the defendant was waiting for her there. The defendant then confronted Ms. Thomas, and when she tried to walk away, he grabbed her and a fight began. Ms. Thomas advised that she had visible injuries on her arm and upper body from the altercation, and was able to send pictures to the officer that was following up on her case. Your Honor, we are requesting the $3,500 surety. We do believe the defendant is a danger to the community, as this was an attack on someone that he did not know, and just didn't like the answer that she gave to his question. Further, he waited for her in the lobby of the workplace and attacked her on the business property by grabbing her and leaving those visible injuries on. So we are requesting, based on that, the $3,500 surety bond with the conditions as stated. We were able to speak with our victim in this case, and she did state that the defendant used to be employed at the location, but he is currently not allowed back on the property. She did state that she has not seen or heard from him since the incident, but she definitely does not want any contact with him. She is supposed to be on Zoom, Your Honor, so you can sound for her when you're ready. Thank you.
All right. Ms. Kim?
Yes, Your Honor. I would like to address that Mr. Pierce is 21 years old. Actually, he's recommended for a signature bond, and we would like to request for that. This happened on October 26, 2021, which was almost half a year ago. Ever since then, there was nothing going on, no other violence ever going on. He's not a danger to the public. This is first incident. He does not have any history. We would like to request for signature bond that he is should be allowed to. He graduated from high school, and he has been here in Georgia for 7 years. He has parents, siblings, all here with his nieces and nephews. He has actually a job. He's working for the last 2 months, and he really deserves to have signature bond, Your Honor. Thank you.
Thank you. I appreciate that. At this time, Mr. Pierce is going to receive a $2,500 surety bond. He is to stay away from the location at 1270 West Peachtree. He is to have no further contact with the victim, last name Butler Thomas, and he is to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further?
No, Your
Nothing
Honor.
from the state, Your Honor.
Thank you.
All right. Best of luck to you, Mr. Pierce. Who do we have next?
Position 11, Mr. Robertson.
All right. Good afternoon, Mr. Robertson. Your case is 22 CR 001526Y, in which you're charged with 1 count of battery family violence with an offense date of March the 16th of 2022. I've advised you of your constitutional rights. Do you understand your constitutional rights?
Yes, ma'am.
Do you object to a video hearing today? Can I continue this by video?
Yes, ma'am.
All right, and do you object to your attorney appearing by video?
No, ma'am.
All right. I believe I have first arrest confirming that, Mr. Howard.
Yes.
All right, I'm sorry, I apologize. All right. Let's see. I see that the victim wanted, I'm sorry, are you here? What was the victim from the last case's name, Ms. Bridgewater?
Yes, I'm here.
You would like to make a statement?
Yes, please. I'm sorry, I couldn't get.
You have to turn on your
Or-
video if you'd like to do so. Please raise your right hand and state your name, ma'am.
Marixa Butler Thomas.
All right, please raise your right hand. You swear and affirm the testimony you give will be the truth to the best of your knowledge?
Absolutely.
All right,
I
what
do.
would you like to tell the court at this time?
That this was a completely unprovoked attack. I have photographs. He actually injured me and broke my skin, tore my clothing, and jumped on me outside of my place of business where I run a staffing agency. We have no personal contact. I had no idea why this was even happening. And he fought me like a man on the sidewalk after he followed me outside. And the UPS driver had to remove him from me in order for me to get loose from him. I had, like I said, visible injuries on my body. I have, this happened October. I have to still go in and out of my job, which is located on West Peachtree, across from the Art Center train station. He ran off that day and has never been seen since until you all arrested him. I've been trying to get updates on the case. I go in and out of my job. We now have a magnetic door due to this very incident that we can press to let individuals into the building, because we had, like I said, it was completely unprovoked. So I am not okay with, I want him to receive the extent of what happens, and I will testify, to that, or speak with whomever I need to in regards to that, because that happened in October. Here we are in March, 6 months later, and day in, day out, I'm leaving, going in and out of my establishment, my place of work, feeling unsafe. I don't know if he's around the corner because he hasn't been caught till yesterday or whenever.
All right, ma'am. Thank you so much for making that statement. Bond will remain as previously ordered. He is to have no further contact with the victim and stay away from that location. Thank you. I apologize. What position were we on?
Position 11, Roberson.
Okay, Mr. Roberson, I've advised you of your rights. This is your first arrest. We will go to the state. Ms. Arnold?
Yes, Your Honor. The state is recommending a $4,000 surety. No further contact with DeShannon Taylor. DeShannon spelled DeShannon. Taylor spelled traditionally. A 1-day anger awareness, and no drugs, alcohol, or weapons. Your Honor, this incident happened yesterday at 502 Pryor Street Southwest. Miss Taylor advised that she and her boyfriend were visiting town here in Atlanta, and they got into an argument while they were driving on the interstate. At some point, the defendant hauled off and punched Miss Taylor in the face. He punched her so hard that he left a visible laceration on the right side of her lip. They got off of the exit after that altercation, and at that point, Miss Taylor exited the vehicle. The report was actually called in by Miss Kelly Greenberg, who stated that she heard the couple arguing, and the defendant was telling Miss Taylor to get back in the car. However, when she saw Miss Taylor's laceration, she did in fact call the police, Your Honor. We are requesting this $4,000 surety bond based on the facts of this case, but also because we believe that the defendant is a flight risk. As the defendant is not from the area and was just visiting town, we are concerned that he will not return to court. So we are requesting that $4,000 surety to ensure his return with the conditions as stated.
All right, thank you. Ms. Kim?
Yes, Your Honor. Mr. Robertson is 21 years old, and his girlfriend and he drove to Georgia his girlfriend has a friends and families here in Georgia, and they wanted to move here, and they wanted to kind of look around, and he was looking for a job, and he graduated from high school. Yes, he's from Louisiana, and yesterday was his first day here in Georgia. He graduated from high school. He has 2 years of college. He studied psychology. I spoke with Miss Taylor, and she believes this was complete misunderstanding, and this was way out of proportion. She does not have any desire to press any charges. She wants to be back together with him, and she's the only one he knows here in Georgia. And we would like to request for signature bond so he can get back to where he should be going to. So that's it, Your Honor. Thank you.
All right, Ms. Taylor, if you would like to make a statement at this point, you can unmute your screen. Please raise your right hand. Please state your name for the record.
Shannon Taylor.
All right, Ms. Taylor, do you swear and affirm the testimony you give will be the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down. What would you like to tell the court today?
I would like to tell the court that the situation was completely out of context. It wasn't as serious as it was, and I did provoke my boyfriend. I put my hands on him first, and he put his hands up to like block my hit. It wasn't like he just deliberately hit me. He's never done that before. We've never had a domestic dispute in our relationship. He's not a violent person. I was mad at him for a conversation that took place in the car, and didn't know how to control my feelings, and I put my hands on him, and he blocked my hand, and I hit myself. That's why I didn't call the police, because I knew that it was my fault. But when a lady saw me getting out the car, you feel me, she was worried about my well-being, and she took it upon herself to call the police. But as I was trying to tell her that the situation did not call for all that, I didn't want to press charges or anything, and there was nothing serious that actually happened. So we had just got to Atlanta. We hadn't even checked into our hotel room yet, and I didn't know what was going on with him. I didn't know the police had locked him up or anything. I didn't know anything. So I took it upon myself to come back to Houston because I was worried and I didn't know what was going on, and I had other stuff to take care of because what we planned to do it didn't follow through. So on his behalf, it was never like he just was like angry and just like attacked me for no reason. Like, I did provoke him. I did say some hurtful stuff to him, and the whole situation transpired out of a verbal argument. It was never anything domestic. I've never had any physical domestic history with him or anything. I don't feel like I'm unsafe around him. I don't feel like he's a danger to me. And I mean, I don't feel like the charges that is really serious, because it wasn't like anything intentional, because I was the one who provoked it. So I really just wish that the court would just drop the charges. I do not proceed to press charges against them. I do not feel unsafe or in danger or anything. And
I think I understand. Thank you so much. All right, at this time, Mr. Robertson is going to receive a $5,000 surety bond. He is to have no further violent contact with the victim, last name Taylor. He is to have no weapons, drugs, or alcohol as a condition of this bond.
I have a question.
Very limited, Ms. Taylor.
I'm not sure how Georgia's bonds and state laws work, but I'm not understanding what is a surety bond.
That's like, he's gonna have to go through a bonding company to get out.
So,
that's what you have to pay to get out.
What does the bond say to? So I can be able to contact his mother and let them know and everything.
It's a $5,000 surety bond, so he needs to call a bonding company and they'll assist him with that, okay?
Okay, yes, ma'am.
All right. That's
Judge, does he have to stay away?
No state. They're from out of, no state. All right. Who do we have next?
Position 9, Mr. Neptune.
All right. Good afternoon, Mr. Neptune. Your case is 22 CR 001524E, in which you're charged with 1 count of battery family violence with an offense date of March the 16th of 2022. I've advised you of your constitutional rights. Do you object to the video hearing or to your attorney assisting you by video at this time?
No, ma'am.
All right. Let's see. Not first arrest, so Mr. Howard.
Third arrest, 2017 battery, not prosecuted. 2009 shoplifting, PTR.
Thank you. Ms. Arnold?
Yes, Your Honor, we are requesting a $5,000 surety bond, a stay away from 18-R Cedar Run in Sandy Springs, no further contact with Chala, spelled CHALLAH, Muqueed, spelled MUHQUEED, a one-day anger awareness, and no drugs, alcohol, or weapons. Your Honor, this incident happened yesterday at the Cedar Run location. Ms. McQueen advised that she and her boyfriend, the defendant in this case, were having an argument about rent money. During that argument, the defendant got on top of her on the bed and forced Ms. McQueen's legs open, leaving her with visible injuries. Ms. McQueen's son was also present during the time of that altercation, but we did not have any information for him, and we did not have any contact information for the victim, but he was there during the time of the altercation per the warrant, and stated that he did hear his mother screaming and saw the defendant on top of Ms. McQueen. Your Honor, we are concerned that the defendant will reoffend. Although the battery from 2017 was dismissed, he was in fact still arrested for that battery in DeKalb County. Additionally, based on the facts of this case where the defendant got on top of our victim and spread her legs open, leaving her with visible bruises, we're not sure where that would have gone if the son was not there to come in the room. So we are very concerned for her safety, Your Honor. So we are requesting, based on the facts and the fact that we do believe the defendant might be reoffend, the $5,000 surety with the conditions as stated.
Thank you. Ms. Kim?
Yes, Your Honor. Mr. Neptune is 55 years old and he wants to move out. Actually, about that 2017, which was not prosecuted, they both, not only Mr. Neptune, but Miss Shala Mulkeed, they both were arrested. And this case, my client says that he was not a primary aggressor at all. It was her who started the fight and framed him to be in awkward situation. However, he completely denies the allegation. And right now, he has been here in Georgia for about 13 years. He has his children, son, grandson, all here in Georgia. He even has his job. He has been having that for 20 years. And he graduated from high school. He went to college for 1.5 years for radiology x-ray technology. And he's been none of them has been actually a violence-related arrest at all, except the 17. They were both arrested and nothing was prosecuted. Thank you, Your Honor. We would like to request for a signature bond, and we do not mind stay away, no further contact whatsoever. We just need one time law enforcement officer for personal belongings, and he does not want to contact her at all because he feels unsafe around her. Thank you.
Thank you. Mr. Neptune is going to receive a $3,500 surety bond. He is to stay away from the location on Cedar Run. He is to have no further contact with the victim, last name McQueen. He is to have no weapons, drugs, or alcohol. He can return to that address one time with a member of a law enforcement to get any possessions he might have at that location.
Thank you, Your Honor.
All right, best of luck to you, Mr. Neptune. Who do we have next?
Judge, it was a $3,500 surety bond. I'm sorry.
Yes.
Thank you.
Position number 1.
All right. Good afternoon. Are you Monica Arnold? Are you Monica Arnold? Yes. Okay. I'm not sure if you've heard your constitutional rights, so I will go through them. You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney at this proceeding. Do you object to me conducting this hearing by video today? Do you object to your attorney assisting you by video?
No.
Okay, thank you. Let's see. First arrest, so we'll go straight to Ms. Tortorella.
Yes, Your Honor. The state recommends for the battery family violence a $4,500 surety bond. The conditions is that she do not return to the incident location at 4323 Shamrock Drive in Atlanta, Georgia. That she have no contact with the victim, Michaela Moody, and that's spelled Mekaylah. Moody is spelled Moody. That she take a one-day anger management course, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on March 12, 2022, at around 7:50 p.m., the defendant, juror Monica Arnold, did batter victim Michaela Moody by hitting her in the face several times, causing a large scratch and redness to her left eye. The victim is a defendant's niece who lives with the defendant. The incident occurred at 4323 Shamrock Drive, Atlanta, Fulton County, Georgia. Your Honor, I understand this is her first time committing an offense. However, this offense was violent in nature. It left injuries upon the victim, and we do have concerns for the victim's safety, as well as concerns that she may intimidate the victim, given the fact that they do live together. So for this reason, Your Honor, we do feel a surety bond is more than reasonable for this case.
Ms. Gant.
Thank you, Your Honor. Mr. Monica Arnold is 45 years old. She is a long-term Atlanta resident. She is a mother and a wife. She has been married for over 23 years. She has 5 kids with her husband, and she also took custody of her sister's 5 children, including the complaining witness, Michaela Moody. Your Honor, in the home, there are present 7 children. And of course, Ms. Arnold is really tapped in her capacity to provide for those children, and therefore she does not have the means to pay much toward bond. Your Honor, we are opposed to a stay away at 4323. That is the residence, the family home. There is a mortgage there. Ms. Arnold's name is on that mortgage. She has been at that residence since 2016. She completed high school. She is also disabled and has been so since 2015. She's receiving Social Security disability for conditions that cause arthritis in her back. Your Honor, she denies these allegations. She states that she was acting in self-defense. She states that the minor MM curses her out. She states that she was merely asking her to take the trash out. In turn, the minor child spit on her. She basically pushed her hand and knocked her. She hit the minor child, basically hit Miss Arnold, and she was more so defending herself. Miss Arnold has informed me that she has also been in contact with DFACS, who has in fact visited her. She states that she is requesting to have the minor removed from her home. She states that she also was taking care of or had custody of the minor child's sister, and also had her removed from the home for the same behavior. Your Honor, I would ask that in light of this DFACS involvement, that Your Honor grant visitation in accordance with the DFACS order. And Ms. Arnold informs me that she has not been instructed to not return to her home, nor continue to have contact with Michaela Moody. I was unable to reach out to Ms. Moody, to the minor, because she does not have a telephone. We heard from the state that this Ms. Arnold does not have any prior convictions. I am recommending a signature bond, as she is recommended through pretrial. Again, we are opposed to that stay away, Your Honor, and would ask that the court issue visitation in accordance with the DFACS order. Thank you.
Is Miss Moody is a minor?
Miss Moody is a minor.
And Miss Moody is living with Miss Arnold?
Yes, Your Honor, she has custody of her.
And she has custody of her. And there are other adults who reside in the home?
Yes, her husband lives there.
Okay.
Your Honor, in light of the circumstances, now that opposing counsel has stated all this on the record, if we do still impose a stay away until they can produce a defects order, and then we would recommend that the state would recommend that the defendant follow the defects order, and if that be okay with Your Honor.
I'm not sure I understand what you're saying, Ms. Tortorella. You're saying that until such time that the child is actually removed, you're asking that Ms. Arnold be prohibited from returning to her home?
So my understanding is that the child's still living at the location. Is that correct?
Right, that's my understanding as well, correct? Ms.
Okay.
Gant?
That is my understanding as well, and she's actively taking steps to have that child removed from the home.
Okay, so if my recommendation is that the stay away be imposed until she produces that defects order.
And the child.
So then
Okay.
they can follow the defects order.
I understand. I really hate to do it, but I also can understand that we don't want to displace the victim. Ms.
She does
Gant,
not have an alternate residence, Your Honor. She does
I
not.
understand that, but the problem is we can't send her back into a situation where there's also a victim. There's no other place she could stay temporarily at this time until that child is removed.
Ms. Arnold, may you clarify if there is an alternate residence for the minor child?
No, nobody wants to deal with her because of her behavior.
Oh,
Nobody.
Not the child, but is there a place that temporarily, I hate to even consider, we have to consider all dynamic solutions here. Is there a place temporarily, Ms. Arnold, that you could stay until that child is removed from your home?
I could stay with my mom, but who's gonna pay my bills? I mean, I'm paying a mortgage on my house and I gotta stay away from my house.
I understand that position that you have, but at the same time, I am in between a rock and a hard place here as well. Ms. Tortorella, no, I don't want you to say, please don't say anything, Ms. Arnold. I understand, don't say anything that might infringe upon your rights. You can ask me a very limited question, Ms. Arnold. Go ahead.
I just wanted to ask you if you can put on a order or something that DFAS remove her from my house. I met with DFAS yesterday, and DFAS said a judge has to do that. So that's why I just want her removed from my house.
I understand. Okay, at this time, Ms. Arnold's going to receive a $4,500 signature bond through pretrial services. She is to have no further violent contact with the victim, last name Moody. Ms. Arnold, you're going to attend a one-day anger awareness course and have no weapons, drugs, or alcohol as a condition of this bond. All right?
And for clarification,
Ms. Arnold, no further violent contact with that child, despite what might be happening with her. Just running the other direction. I don't want you to say anything, Ms. Arnold. I understand. I understand you're in a difficult position as well. All right. The court does understand that it's best for now if your husband provides primary care for that child until she can be released. I understand. I understand. But at this time, if your husband could do the best that he can, and I'm not going to say no contact, but do your best to limit contact with that child, all right?
I'm not going to speak to her, I'm not going to talk to her. I see her go the other way.
I think that's best for right now.
I'm just trying to get the best to remove her.
Yes, Ms. Arnold, I understand. Don't say anything else. I don't want you to say anything that might be used against you. But that will conclude your case. I've given you a signature bond, all right? Best of luck to you.
Position number 8.
Your Honor, may I just clarify, you did not impose a stay away, correct?
I did not.
Okay, thank you, Your Honor.
All right. We're going to position number 8, I was told.
Yes, ma'am.
Is there any chance we could take Ms. Watson Cafe's position? I know that may mess things up, but I do see the South Annex is on the screen. Can we take that position? Okay, I tried again. Ms. Watson Cafe. We're at position 8. I tried. Miss, is your name Anshise Levison?
Anshise Levison.
Anshise Levison. Ms. Levison, Your case is 22 CR 001539C, in which you're charged with simple battery with an offense date of March 16th of 2022. I've advised you of your constitutional rights. Do you understand them? If not, we'll go through them again. You said yes?
Yes.
All right, thank you. Do you object to a video hearing today?
No.
Do you object to your attorney assisting you by video?
No.
All right, thank you. I have first arrest, so we'll go straight to Ms. Tortorella.
Yes, Your Honor. The state's recommending a $3,000 surety bond, but we're not opposed to a signature in this matter. The conditions is that she have no contact with the victim, Mary Am Razagzadeh, and I'm going to spell that for you, Your Honor. It's Maryam, and then the last name is R-A-Z-Z as in zebra, A-G-H-Z as in zebra, A-D-E-H. And one day anger management course, no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on March 16, 2022, around 8 p.m., Officer Bacon of the Johns Creek Police Department responded to the public shopping plaza at 5805 State Bridge Road in Johns Creek, Georgia, in reference to an assault. The officer spoke to both parties, the defendant, Anjanese Levison, and the victim, Maryam Razagzadeh, about an altercation that occurred between the two of them. The victim advised the officer the defendant started yelling at her after she unintentionally hit the defendant's car with her car door. The victim said that the defendant then proceeded to shove her to the ground. The defendant advised the officer she put her arm out to stop the victim from walking away, and the victim fell. An independent witness, Mr. Joseph Braddus, and that's for the record, is spelled B as in boy, R-A-D-D-U-S, told the officer he saw the defendant shove the victim to the ground. The defendant was arrested by the officer, and all these events occurred in Fulton County, Georgia. Again, Your Honor, this defendant only has one cycle, which is this case, and for that reason, and given the facts of the case, Your Honor, we're recommending a signature bond.
Okay, thank you. You're recommending a signature bond, Ms. Tortorella?
Yes.
Okay. Mr. Howard, really quickly, I have pretrial jail. Was that correct? Did I write that correctly? Should it be with pretrial take this case?
You should have jail.
Okay, thank you. All right, Ms. Gant.
Your Honor, we are unopposed to this signature bond, and we all are also unopposed to the no contact order. Ms. Levinson is 43 years old. She has been in the Atlanta area for about 3 years. She is from Mississippi. However, she has ties in this area in that she works at a company, ThriveWorks, in I believe it is Decatur. As a counselor, she has been in that position for the past 2 years. She also leases an apartment in Duluth. Your Honor, we are unopposed to, again, we're unopposed to that no contact order. Ms. Levinson has a master's degree in counseling and psychology. Again, she works as a counselor at ThriveWorks. She denies the allegations. She states that there is no way that the witness could possibly see what happened because that person was standing behind her. She also denies pushing the complaining witness, Ms. Marianne Ragazadia, to the ground. She states that she put her hand up to stop the complaining witness from approaching her. She states that when the complaining witness exited her vehicle, she hit Ms. Levinson's car door. Ms. Levinson was merely asking her to hold on for a moment so that she could, that they could both look to see what was going on with the damage. And she states that the complaining witness approached her in a threatening manner. She merely put her hand up to avoid having any contact. And further, Ms. Levinson also stated that when the EMT officers arrived, she overheard the complaining witness change her story. She states in one instance that she fell, and she also stated in another instance that she was pushed. Your Honor, for these reasons, I am requesting again that signature bond or consent to that signature bond in light of my client's negative history. Thank you.
All right, I'm going to accept the state's recommendation and give her the signature bond. It'll be an $8,000 signature bond through the jail. She is to have no further contact with the victim in this case. and she is to have no weapons, drugs, or alcohol as a condition of this bond. All right, best of luck to you, Ms. Levison. That will conclude your case. Who do we have next? Who do we have next? Hi, good afternoon.
Good afternoon, Your Honor. I have four ladies here. They need to hear their rights. They are the four statute of the Redlight Reserve. These four ladies need to get their rights.
Yes, I'll give them their rights. Can we please take Ms. Smith? I believe it's Ms. Smith, who's represented by Ms. Watson Cafe. Can we take her first?
Yes, Ms. Smith.
That is correct. That is your client, correct, Ms. Watson?
Oh,
it's Tykera Smith. I think the cross defendant shares the same last name.
Oh, and I believe, Ms. Kim, did you request earlier to take two cases at once? Was position 13 one of those?
Yes, Your Honor.
So we're gonna do 13 and 15 essentially together?
Yes,
All
Your
right.
Honor.
All right. All right, everyone at the South Annex, I'm Judge Melanie Williams. Today is March the 17th of 2022. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding. This proceeding is being recorded, which means that it's being recorded and live streamed, which means that any member of the public can log on and watch this particular proceeding. I believe we're ready to begin now that you've been advised of these rights. If you object to the video hearing, I will speak with you specifically before each case is taken up to confirm that we can go forward in this manner today. Ms. Smith, your case, you are April Smith?
Tykera Smith.
Oh, you're Tykera Smith. Okay. Ms. Tykera Smith, your case is 22 CR 001530J, in which you're charged with one count of battery family violence with an offense date of March the 15th of 2022. Do you object to the video hearing?
Yeah, I'm rejected.
Do you have a problem with us doing this today by video?
No, ma'am.
Do you have a problem with Ms. Watson Cafe assisting you by video?
No, ma'am.
All right. We're gonna go forward. This is her first arrest, so we will go straight to Ms. Arnold.
Yes, Your Honor. So normally the state tries to determine the primary aggressor when officers are unable to do so, but we also found it difficult in this case. So we are recommending a $5,000 signature bond, no further contact with April Smith, spelled traditionally, a one-day anger awareness, and no drugs, alcohol, or weapons. Your Honor, as you know, this is a cross defendant with position 13. This defendant happened on March 15th at 1371 Kimberly Way, Southwest in Atlanta. Ms. Smith advised that she had been living at her daughter's apartment for about a month and a half. And on the day of the altercation, she was in the bathroom. She stated that the defendant's boyfriend unlocked the bathroom door and she began to yell at him. She stated that when she exited the bathroom, the defendant began to attack her and scratch her. At some point, Miss April Smith also advised that her weave was pulled off of her head. Officers made note that there were scratches on Miss April Smith's chest and her neck area. But as I stated before, they were unable to determine the primary aggressor, and both April and Tykera Smith were arrested at that time. So, Your Honor, again, based on the warrant, we had a hard time deciphering who the primary aggressor was. So we are requesting a $5,000 signature bond in this case.
All right, and let me clarify, is the state requesting a stay away?
Not for Tykera.
Okay, is the state's position that this is her home?
Yes, Your Honor.
Okay, Ms. Kim, I'm sorry, Ms. Watson Cafe, I've been calling for you and then finally it's your turn, I got it wrong. All right.
No problem, Your Honor.
Any objection to the state's recommendation and any clarification needed?
We don't object to the signature bond, Your Honor, but we do object to the no further contact. Ms. Smith has requested no further violent contact with her mother. As the state has already stated on the record, there's a It's hard to determine based on the warrant application, the affidavit, who the primary aggressor was in the situation. There was also a laceration found on Miss Takira Smith as well. So both of them had bruises. With that being said, this is Miss Takira Smith's residence. Her mom does currently live there. We are seeking a no further violent contact rather than a no contact order, Your Honor.
Thank you. Ms. Kim, do you represent Ms. April Smith?
Yes, Your Honor.
And what is your client's position on contact and any type of stay away?
No further violent contact would be enough, and they live together, so.
Thank you. Ms. Arnold, I'm assuming the state has the same recommendation for both positions 13 and 15 in light of the facts of this case?
Yes, Your Honor. With the exception, as I mentioned before, that we do intend to ask for a stay away for Miss April Smith, since we determined that it's Miss Takira Smith's home. And we hear the defense, but I just want to put it on record that we would object to no further violent contact, as this just happened. So there has not been enough time to cool off. So we would still stand on our position that there should be no further contact and a stay away from Miss April Smith. And as Ms. Watson Cafe did mention, one additional fact that I did not put on the record when speaking about position number 15 was that Miss Smith did have a laceration on her left cheek as well that came about from this altercation.
Okay, thank you. All right, at this time, Ms. Takira Smith is going to receive a $5,000 signature bond. She is to have no further violent contact with the victim, last name Smith. She must take a one-day anger awareness course and have no weapons, drugs, or alcohol as a condition of this bond. Are there any questions? I'm sorry, Ms. Wick.
Through pretrial.
Through pretrial, yes, ma'am. Through pretrial services. All right, are there any further questions from either party?
No, Your Honor.
Are you also referring to Miss April as well?
No, we're gonna still take her up separately.
Switch,
But
please. Come on, Miss.
I just want to make sure the jail gets for Miss Takira Smith, if the jail can make sure to get my contact information to her. They have my phone number.
Ms. Smith appears to have a question. If it's very limited, but the best person to ask is your attorney. Ms. Smith, your question?
I have a question. So we still gonna be living together, or what's the case may be? I don't know.
I did not require that your mother stay away from you. Are you modifying? I will allow you just to very limitedly speak. Are you asking that your mother be not allowed to live at the location? You are?
Yes, ma'am.
So you do not wish to have any contact with your mother?
No, ma'am.
Okay. I understand that position. All right. So let me think about this. The $5,000 signature bond will stand. I will not, Mr. Takira Smith is to have no further violent contact with her mother. So we'll put it that way. All right. So that means, but see, in this case, I don't want to explain too much. Ms. Smith, this incident location is your home. We're going to take up your mother's case separately, and there may be some other facts discussed in the context of your mother's case. All right. Okay. All right. So you are to have no further violent contact with your mother.
Okay.
All right.
Okay.
So it's no contact or no further
violent?
No further violent contact.
Okay.
All right, so now we're gonna take Miss April Smith. All right, I've heard, are there any additional facts from either the state or the defense at this point?
Yes, Your Honor, I would like to address some things. Well, first of all, Miss Smith is 41 years old, and Miss Smith pays for the rent and food for that house. Only reason that there was any kind of altercation was because boyfriend visited, and we would like to request that no further violent contact, since she's the one who's taking care of this household bill.
But this is Miss Kim. Let me read Miss Smith her case number. Miss Smith, your case is 22 CR 001528F. in which you're charged with 1 count of battery family violence with an offense date of March 15th. Do you consent to this video hearing?
Yes,
And you consent to your attorney assisting you by video?
yes.
Okay, thank you. The point of clarification though, Ms. Kim, and perhaps Ms. Arnold, whose home is this? Despite who's paying the rent, whose name is on the either mortgage or lease?
Now that, Your Honor, I do not know whose name is on the lease, so Ms. Kim would be better to answer that. But based on the facts in the warrant, Ms. April Smith, so there were 2 varying facts from the warrant. Ms. Nicaria Smith alleged that her mother was staying with her and did not pay any bills or any rent, and she was trying to get her keys out of her mother's purse, which is to get back her keys, which is how the altercation occurred. Miss April Smith advised officers that she helps out with the kids and helps take care of them. And from that, I gather that that is her contribution to the household, not that she's actually paying any rent or paying any money, but she's there assisting her daughter with the kids. So if Ms. Kim has further information about who's actually on the lease.
Right, whose home is it actually? That's what I need to clarify, Ms. Kim. Do you know?
I do not know exactly whose name is on the lease. From my memory, I think none of them actually has their names on the lease. I think they are subleasing from their friend, but I would like to clarify with Miss April Smith here.
Okay, Ms. Kim, if you would ask your client that very limited question about whose house it actually is.
Miss April, would you please tell the court that whose name is on the lease?
The apartment is being subleased by somebody else.
Okay, so it's so neither party really lives there. Is that, I mean, no, neither party has actual possession of this house.
Right.
Okay, what I'm gonna do is is Miss Watson Cafe still on the line?
Yes,
I'm gonna change it to just a no contact order at this time without clarifying who lives where, because it seems to be unclear whether or not it's the mother's home or whether or not it's the daughter's home. So it's hard to impose a stay away without knowing whose home it is. And Ms. Arnold, go back again. The police report indicates that.
Yes, according to Ms. Tykera Smith, she stated that her mother had not been paying her rent, and that it was because of this that she was trying to get her keys back from her mother, and she went into her purse, and that's how the altercation began, with the tussle between the purse. And when Miss April Smith gave her statement to police, she advised that she had been taking care of the kids and assisting in the home, as that was her contribution, not specifically that she had been paying rent.
Ms. Watson, do you have any information regarding whose home it actually is?
My understanding is that it's Miss Tykera Smith's home, and in the warrant it says that as part of her statement, Miss April Smith stated that she has been living in her daughter's apartment. So even in the statement that the officer took, it was still stated that it was Miss Tykera Smith's apartment.
I'm gonna change it to both parties. I'm gonna amend the orders. There's to be no further contact between the parties, and Miss April Smith is to stay away from the incident location. Both of them will receive the $5,000 signature bond through pretrial, and they will both take the 1-day anger awareness and have no weapons, drugs, or alcohol. But they are to have no contact at this time.
Okay.
But April
Yes, Your Honor.
stay away from the apartment?
Yes. If you have a question, Ms. Smith, the best person to ask is your lawyer, but I will hear a very limited question.
I have a question.
Very limited. You don't want to say something that stays.
So because I've been on the premises for over 30 days, a month and a half, and I have been contributed. And one of the reasons why the outcome came was because of the marijuana smoking on the premises.
Ms. Smith, I'm going to admonish you not to say anything else. My order will stand. And if you have further questions, please speak with your attorney. All right.
Please call me. I'll talk to you. Thank you.
All right. Best of luck to you. Yes, Ms. Arnold.
I might have missed if you gave her a one-time escort, but just to prevent any further complications, I don't know if she needs to go back and get things of that.
Well, yeah, she can have a one-time escort with a member of law enforcement. All
Thank
right,
you, Your Honor.
that will conclude Ms. Smith and Ms. Smith's case. We can move to the next position.
Can
Next,
I
we
be
have
excused, Your Honor? Oh, sorry.
Ms.
Yes,
Collins.
you may. Take care, Ms. Montecalvo.
Next is position number 6, Ms. Collins.
All right, good afternoon, Ms. Collins. Your case is 22 CR 001537H, in which you're charged with simple battery against a police officer, criminal trespass, and 2 counts of willful obstruction with an offense date of March the 16th. Do you object to the video?
Homelessness,
No. Can we conduct this by video?
according to your premises, yes, ma'am.
Okay, can your attorney assist by video?
Yes,
Your
if she's
Honor.
available.
Your Honor,
Yeah.
I believe that the state requested a breakout for this position.
I understand. We'll just give her her rights. real
Will I
quick.
be released today?
Okay, please place us in the breakout. I think I understand the concern.
Will I be released today? Just hold on. Just
Hold
calm down.
hold on, Ms. Collins. We're gonna find out what's gonna happen.
Your Honor,
Breakout rooms that y'all previously, y'all guys can rejoin.
Oh, we can just click over to the breakout.
Your
Mine
Honor.
doesn't always work. Yes,
Your
Ms. Gant?
I do apologize for interrupting. Ms. Campbell has resolved her technical issues and she would like to address the court briefly. That's from position 3.
I think the judge went back in the breakout room.
She's in the breakout. Okay.
Y'all guys need to join her in the breakout room.
Okay, thank you. I do apologize for interrupting.
I don't have the little link.
Nor
back.
do I.
Just hold on, please. Thank you.
All right, after speaking with counsel for both the state and the defense, Ms. Collins, you'll need to speak with your attorney following this hearing so that she can explain some things to you. You are going to receive a $4,000 signature bond, $4,000 surety bond at this time. That's $1,000 for each charge. All right?
So due to homelessness, I won't be getting out today because I was stuck in where? A homeless shelter?
Please speak to your attorney. You are to stay away from the College Park MARTA station, should you make bond. And any other MARTA orders that are in place, you need to abide by those. And you are to have no weapons, drugs, or alcohol.
Oh, where's my social?
Don't say anything. And you are to have no further contact with the officer, in this case, Mr. D. Richards. And if you have questions, please speak to your attorney. I don't want you to say anything that may affect you. And the evaluation that we discussed in breakout will be conducted as well.
So as a social worker, what will you do?
I think
I
you
won't.
should.
So how long would I have to be here?
I will call you, Miss Collins, okay? And
So would it be today?
I will call you today, yes, ma'am.
How would you call me? All right, okay.
All right. The best of luck to you, Ms. Collins. I don't want you to say something else.
Yeah, you say that's $1,000 on each charge.
Yes, ma'am.
Is that, hold on. Have a seat over there for me, please. Thank you. Okay, I see three charges, so it's.
Oh, she has two. That should be a 3,000 signature bond.
I see 4.
I'm seeing 4 charges. You don't see. I believe she has.
She has 2 willful obstructions.
She has two willful, 1 criminal trespass, and 1 battery, simple battery. I apologize. So that should be 1,000 on each charge for right now. Actually, yeah, I'll leave it at that. 1,000 for each charge right now, just to make sure that. And she'll be reset to the SAP on March the 31st.
Your Honor, did you say no drugs or alcohol, no weapons?
Yes.
I did. All right, does that complete at the South Annex?
So Your Honor, I have one more, Ms. Zhang, position 17.
Okay.
Come on,
All
Ms.
right,
Zhang, have a seat.
Ms. Zhang, your case is 22 CR 001536A, in which you're charged with battery family violence with an offense date of March the 15th of 2022. I've advised you of your rights. Do you object to the video?
I do not object, Your Honor. I have a simple battery.
Okay, I don't want you to say anything. And do you object to your attorney assisting you by video?
I think she means.
Are you okay with your attorney helping you by video? Is that okay?
Yes, Your Honor.
Okay, thank you. All right, at this time, I have first arrest. We'll go straight to Ms. Arnold.
Your Honor, we are recommending a $4,000 surety bond, no further contact with Adam Levin. Adam spelled traditionally, Levin spelled Levin. A stay away from 6125 Roswell Road, apartment 380 in Sandy Springs, a 1-day anger awareness, and no drugs, alcohol, or weapons. Your Honor, this incident happened yesterday at the Roswell location. The defendant actually called the police because she wanted them to come and get the only key fob that her and Mr. Levin had for their apartment back from Mr. Levin. And when officers arrived, she advised that she did not have any injuries. She just wanted the key fob back. When officers spoke with Mr. Levin, he advised that he had recently just arrived home when the defendant grabbed the key fob. And a few minutes later, Mr. Levin grabbed the fob back from her. When he did, the defendant grabbed his left hand and bit him on the top center of his hand. That bite broke the skin, and officers were able to observe a small amount of blood on his hand. The officers also mentioned in the warrant that the couple had been involved in another incident the day before, where they were arguing in a parking garage over money. They indicated that the couple had only been married for 2 weeks and had already filed for divorce. And at the time of the first incident, Mr. Levin was trying to evict the defendant and offered to purchase her ticket back to Las Vegas, but the defendant declined at that time. Your Honor, we are concerned that the defendant will be a flight risk, as it appears that her home, as we have listed, is in Las Vegas. And she was only here to be with Mr. Levin for their marriage, in which they are now seeking a divorce after 2 weeks. So we are requesting that $4,000 surety to ensure that she will return to court with the conditions as stated.
Kim?
Yes, Your Honor. Actually, I believe that Mr. Adam is kind of like manipulative about the situation. It was him who attacked my client first, and my client was actually protecting herself. He's bigger and he's more aggressive, so it was, she wanted to be safe, and his motive is basically getting more money out of the divorce settlement. So my client has a tendency to be very oh, whatever, I'm too scared, whatever you want, I'll give it back give it to you. So he's using this as fear as his tactics to get the more money out of her. And when I was interviewing her, she came from China to Las Vegas in 2016. Her father is U.S. citizen, and she came to Georgia December 2021. And there's no family members, of course, here in Georgia except her husband. So only person that she can call for bond out is her husband, and who demands more money for her to get out of the jail. And that's very unfair and kind of like extortion. I just feel like that was the tactic that he was using. And also, she's been working as a property manager right now, so she has a ties to the community, and she graduated from college. She has a bachelor's degree. She studied finance and French. She also has one semester of graduate school that she's pursuing. I don't think she is a flight risk. She's responsible. She wants to get this done, even though she may have to go back to Las Vegas because of her husband divorcing her without her knowing that she didn't even know that she was divorced. She does not understand how the legal system here in U.S. works, unlike Mr. Adam, who's very shrewd. Also, 6125 Roswell Road, 380, there's no reason to stay away from that location because it's vacant right now. Mr. Adam moved out. I spoke with him. He's not there at all, and only her stuff is left behind. So I don't think that there's need for stay away. And I request for signature bond, and I think no further contact is totally fine. I think she should have a better person. Thank you, Your Honor.
Thank you. Mr. Howard, question. I know she's recommended to the jail. Is it only because of her residency that recommendation was made?
Yes.
And if I order it, will you be able to keep up with her via Zoom? Can she do virtual check-ins or something?
That's up to you.
I mean, I know it's up to me, but is it physically possible for you to monitor her if I were to order that?
Pre-trial can try. That's all we can do.
All right. I want pretrial to give them their best effort. She's going to get a $4,000 signature bond through pretrial services. We thank Mr. Howard in advance for his valiant efforts. She's going to stay away from 6125 Roswell Road, even though the defense has put forth that it's vacant. She still is not going to go there. She's going to go one time with a member of law enforcement to get any items. She is to have no alcohol, drugs, or weapons as a condition of this bond.
That's per judge. How much is that?
Per judge, $4,000. Ms. Zhang, I know that you don't, you may return to Las Vegas, but you're still going to have to keep up with pretrial services to the best that you can, such that you're not in violation. I'm giving you a signature bond today, okay? If you have questions, please talk to Ms. Kim.
Yes. Ms. Jane, call me. I'll explain to you.
All right.
Thank you, Your Honor.
Is there anything further as it pertains to this case?
Ms. Jane, please not say anything. I'll explain to you. I don't want you to say anything that is gonna hurt your case at all. You got the signature bond. Let's get out. Thank you.
The simply battery, not a battery. Okay. No, that has nothing to
you.
Okay.
All right. Anything further? That concludes the calendar at the South Annex.
Yes, Your Honor. May we be excused, please?
Yes, you may. And I believe there's one position where the appearance has been waived. Is that
Yes,
correct?
yes,
All
Mr.
right.
Smith.
All right, we don't have to advise Mr. Smith of his rights because he is not here.
Yes.
Is he inquiring, is it a medical reset?
No, Your Honor. He wants to have a waiver of appearance, and I filled out the form and submitted prior to the hearing, Your Honor.
Okay. All right. Mr. Howard, do you have the history for him?
No,
No history? You don't have a history, or he doesn't have a history?
I don't have a history.
Oh,
I'll
okay.
refer to the state.
Okay, thank you. Ms. Tortorella?
Yes, Your Honor. I wanted to break out with yourself and Ms. Kim regarding Mr. Smith.
Okay, we can do that.
Thanks.
All should be already in the breakout room. All you gotta do is just set to go back in.
Thank you.
Ms. Kim, you don't see it?
All right, we are back on the record with Mr. Smith's case. Mr. Smith is not present. His appearance has been waived. Ms. Tortorella, can you give us the state's recommendation?
Yes, Your Honor. The state's recommendation for this case, and it's 22 CR 0011416E, State versus Stanford Smith. It would be for the unlawful entry, it'd be $1,000 surety bond, and for the obstruction, it would be $1,000 surety bond, and that would be a total of $2,000 surety bond. So we're asking for the bond to remain as set. The conditions is that he do not return to the incident location at 435 West Peachtree Street in Atlanta, Georgia. That he stay away from all MARTA stations if he has a warning, a one-day anger management. Well, let's scratch the anger management. The condition that we talked about in the breakout, Your Honor, and no weapons, no drugs or alcohol, and no new violations of Georgia law. Your Honor, on February 17th, 2022, at around 6:13 a.m., the defendant, Stanford Smith, did gain unlawful entry into the MARTA Civic Center station at 435 West Peachtree Street in Atlanta, Georgia, without paying the required fare of $2.50. On said date and time, the defendant also committed obstruction against Officer B.M. Steedle, and that's, for the record, spelled Steidle, of the MARTA Police Department, by fleeing the scene. And all these events did occur in Fulton County, Georgia. Your Honor, we do ask that you impose a surety bond on this matter and that the bond remain as set. He does have an open felony case as discussed, and he has convictions, theft convictions going all the way back to 2007. He has a 2021 terroristic threats conviction out of DeKalb State Court, 2015 disorderly conduct and criminal trespass conviction out of DeKalb County State Court, a 2015 criminal trespass, theft by taking conviction out of DeKalb County State Court, just a Superior Court, just to name a few, Your Honor. He's
that's a
had
good picture. I think that's it. Unless you think there's anything specific.
nothing further, Your Honor.
Okay, thank you, Ms. Federell. Ms. Kim, I'm inclined to, after our discussion, I'm inclined to adopt the state's recommendation. Do you object to that?
No, Your Honor.
Okay, so he will receive a $2,000 surety bond with the evaluation. As mentioned, he is to stay away from the MARTA locations and not return to them, not to have any weapons, drugs, or alcohol should he make bond.
That's $1,000 on each charge?
Yes, ma'am.
Okay, very good.
All right, I believe we've addressed the entire calendar. Do we want to review it?
Absolutely.
Yes, Your Honor.
Your Honor,
I'm gonna head out before y'all continue. I don't need to review it.
Thank you. Have a great evening, Mr. Howard. Yes, Ms. Gant?
Your Honor, I do apologize. If the court has addressed Ms. Collins in position number 3, I apologize if I did not hear that. She is informing me that she has not been heard by the court.
Who is?
Ms. Collins. She is the complaining witness for position 3, Rodney Booker.
Oh, Ms. Campbell, we spoke with Ms. Campbell previously. That case is now closed.
Okay, thank you, Your Honor.
All right, we're gonna review the entire calendar.
Your
Ms.
Honor,
Campbell,
you never addressed my request for contact with no violence, because we do live together and I'm supposed to be bonding him out.
My order will not change at this time, Ms. Campbell. All right, let's review the calendar.
And let me say this before we get started on this last case. Will you send me over the order for the judge to sign on that MH, whoever's responsible for that? Can you go ahead and send that over before the judge leaves? Thank you. Okay, again, the reset date for SAP is going to be March the 31st. Position number 1 is reset further notice with a $4,500 SOB through pretrial. Position 2 is reset further notice with an $8,000 SOB through the jail. Position 3 is reset SAP with a $2,500 good bond. Position 4 took a plea, which is time served. Position 5 is reset to the SAP calendar with a $3,500 good bond. Position 6 is reset to the SAP calendar with a $4,000 total good bond. Position 7 is reset further notice with a $4,000 SOB through pretrial. Position 8 is reset further notice with a $8,000 SOB through the jail. Position 9 is reset to the SAP calendar with a $3,500 good bond. Position 10 reset to the SAP calendar with a $2,500 good bond. Position 11 reset to the SAP calendar with a $5,000 good bond. Position 12 reset to the SAP calendar with a $500 good bond. Position 13 is being reset further notice with a $5,000 SOB through pretrial. Position 14 is going to the SAP calendar with a $2,000 total good bond. Position 15 is being reset further notice with a $5,000 SOB through pretrial. Position 16 is reset further notice with a $4,000 SOB through pretrial. And position 17 is being reset further notice with a $4,000 SOB through pretrial per judge. Are there any questions, comments, or otherwise?
Yeah, I have two questions. For Gia Zhang, I'm sorry, Your Honor, I have it with the stay away, one-time escort, and no drugs, alcohol, or weapons. Did you order no further contact with Mr. Levin?
Yes, no
I have
further.
it as that.
Yes, that's what,
Okay.
yes, no further contact, yes.
And then on the cross-defendant case with Miss April Smith and Tykeria Smith, I know you ordered no further contact for both parties. Was Miss April a stay away, or was it just no further contact for both
Miss
parties?
April was a stay away.
Miss April received a stay away and no
Okay.
contact.
Thank you, Your Honor.
Any other comments, changes, questions, or corrections? Hearing none, will be in recess until tomorrow, March 18th, at which time Judge Law will be presiding. Everyone have a great afternoon, great rest of your weekend, and enjoy your St. Patrick's Day. Take care, everyone.